Ladies and gentlemen, esteemed panelists and conference participants, friends present here virtually, both physically and virtually, good morning. On behalf of the Permanent Court of Arbitration, it is my absolute pleasure to welcome you all to our headquarters here, the Peace Palace, for the 2026 Hague edition of World Arbitration Update. Today we gather in the Administrative Council chamber of the Peace Palace in The Hague to discuss recent developments and future trends in how climate change decisions of international courts and tribunals influence and reshape international investment arbitration and the balance between environmental protection and investor rights. Climate change is one of the biggest challenges of our time and virtually affects every aspect of our lives. It has prompted extensive international and domestic regulation, transforming legal and economic frameworks across jurisdictions. In parallel, a broad spectrum of climate change-related disputes has emerged, ranging from interstate proceedings to actions by individuals and civil society against governments, to claims brought by and against corporations as businesses and investors. Many of these cases have arisen in the realm of international arbitration, where issues relating to emissions reductions, the energy transition, climate change-related regulatory changes, and the calculation of climate change-related loss and damages are becoming increasingly prominent. And many more disputes are certainly on the horizon. The PCA has had a long history and significant experience in administering environmental disputes, including climate change-related disputes. In fact, in May 2000, the then Secretary General of the PCA, His Excellency Mr. Chaco van den Hout, posed a timely question to an audience of lawyers, judges, and arbitrators convened to attend a conference hosted by the PCA right here entitled, I quote, "International Investments and the Protection of the Environment, the Role of Dispute Resolution Mechanisms." And he said, and I quote, "The need for a linkage between objectives of the two sets of norms imitated above has become a pressing issue. When international environmental conventions have an impact on investment behavior in such a way that the objectives of environmental protection are achieved, the linkage is there. That is not the case, however, when two sets of norms actually conflict with one another. Should there be a hierarchy of one set of norms over the other? What are the implications if and when domestic law interferes? And conversely, what are the implications of international processes for domestic legal orders, for nationals, for investors?" 26 years ago, and we continue to grapple with exactly those questions. Those questions were asked prospectively back then in recognition of the growing significance of environmental governance for international investment and economic activity. The statement itself was also a reflection of the culmination of a series of steps that the PCA had itself taken, encouraged by the 1987 Brundtland Commission, the UN body that would coin and define the concept of sustainable development, who observed that, quote, "Capacity and procedures for settling disputes are largely lacking at the international level, particularly on environmental and natural resources management issues," and recommended that, quote, "The capabilities of the Permanent Court of Arbitration to deal with environmental and resource management problems should be strengthened," unquote. That was then followed by the 1992 Rio Earth Summit that gave rise to the UN Framework Convention on Climate Change. Attempting to make our own contribution to these efforts, the PCA has, since the early 2000s, developed specialized environmental rules for arbitration and conciliation, and engaged in identifying arbitrators with special crossover expertise in these two domains. These and other rules have been used in arbitral proceedings between states, state entities, and the private sector, raising a variety of issues relevant under the core international climate change treaties, including sea level rise, sustainable development, the Clean Development Mechanism joint implementation, climate finance, and green technologies. Over the course of today, However, we will also explore how developments before our sister international courts and tribunals, including our neighbor here in the Peace Palace, the International Court of Justice, will impact investment arbitration and energy and mining disputes, including questions of jurisdiction and quantum, as well as what the future holds more generally in climate change-related interstate and investor-state disputes. I would therefore like to express my sincere thanks to the speakers, to the organizers, and the participants who had made this event possible. I wish you all a productive and engaging conference, and I look forward to the fruitful discussions ahead. Thank you.
Well, good morning, everyone. For those of you that might not know me, my name is Jose Antonio Rivas, and I am one of the co-founders of the World Arbitration Update, and it is a true humbling pleasure to be in this room and hosted specifically by the PCA in this occasion. We basically decided to have as a topic of World Arbitration Updates the climate change obligations advisory opinion of 2025, June 2025, as an obvious topic. And let me share with you part of the sort of ethos that conducts World Arbitration Update. It was created specifically to do two things. One, to update the international community on three topics. One, public international law. Two, investment arbitration, conceiving that investment arbitration is part of public international law. And three, international commercial arbitration. So those are the first three aspects of the first objective of the World Arbitration Update. The other one is decentralizing international arbitration as means not only to have international arbitration within the main centers like Paris or London or New York or Washington, D.C., but trying really to reach out to other areas in the world to give a platform to various lawyers, both counsel, arbitrators, practitioners that may be in any continent of the world. So as a reflection of that, we have had World Arbitration Updates this week already in Bogota, today in The Hague, and tomorrow in Budapest. And in prior editions, we've had World Arbitration Updates in Beijing, in India, in Poland, etc. So I won't name all the countries, but basically we've reached all the continents except Australia and New Zealand. So that is part of sort of the ethos that conducts us. And now, on World Arbitration Update for this year here in The Hague, it was quite obvious that we would do this topic. Last year we did the influence of public international law, and specifically the ICJ decisions on investor-state arbitration. And this leads me to the main theme that sort of inspired having the speakers and the order in which they are organized throughout the day. If you see the program, you will notice that it very much resembles either an investment treaty in terms of structure. You would have jurisdiction, and then you would have merits, and eventually you would get to quantum. Or it resembles very much an investor-state or public international law proceeding, where you go in through jurisdiction, merits, and then quantum. So we try to replicate that here. So that's sort of the order in which everything was set. And the other part that we are, that has driven the conference is the strong belief that in order to fully understand investor-state arbitration, one has to take a step back and realize that it is part of public international law, and that in order to fully be a performative arbitrator in invested arbitration, you really have to go to the sources of public international law, into the treaty interpretation principles, and start from there. So that is what has inspired this conversation. That's in terms of structure. In terms of why those two topics, it might be related to a malady of our times in the 21st century. And that is, it is very easy, either ideologically or profession-wise, to be solely in a silo of a specific profession, or even in a subgroup of a specific profession. So one can be strongly in purely environmental law, or in investor arbitration without any communication. An example of that, which I may refer to, is a lecture by Stiglitz and 200 economics academics and some law professor, written to a president of a Latin American country, which happens to be my country, in Colombia, or one of my countries, and asking for leaving the whole investor arbitration system. And on the other hand, you can have investor arbitration conceiving that it is a completely isolated world. So the issue is, there's this poles that may be very much informed in terms of knowledge within their own fields, but the sense here was that communication between the various lines of thought is really important. So what you will see throughout the day is speakers that come from various facets of international law, that have various views, and the idea is to bridge those fields in order to have a conversation, and a conversation in order to ultimately have, if you will, a sort of dispute resolution in theoretical terms too, all driven by the principles and specifics of public international law. So that's what has driven and inspired this conversation, and hopefully we will get somewhere through that. This is not a unique conference. While putting it together, we have also seen that there have been publications, and there have been also been similar but not exact conferences. There is already a specific publication by ICSID on similar topics, but we believe that the structure is somehow very inclusive and diverse. So with that, I would like to say thanks to some of the minds behind them, especially Ian Laird, my co-chair of the conference, and Reza Ekbar, and Yannick Radi, and of course our host, Martin Doe. And I would also like to acknowledge the presence of Jean-Marc Touvenin, who was also our keynote speaker last year, the president of the Hague Academy, the Secretary General of the Hague Academy. Merci pour être ici avec nous une deuxième fois. And you know, the team that is behind it, some in DC, some in Bogota, including Momin, who is watching us and sort of conducting us from afar, and two other fellow parts of the team in Colombia, Maria Jose and Camila. So with that, Ian, please.
My name is Ian Laird. As Jose Antonio mentioned, I'm one of the co-founders of the World Arbitration Update. Only a few final points. First, I just want to make sure we thank our sponsors, Xstrategy, Kroll, NERA, Wamba Bond Dickinson, and Sovereign Arbitration Advisors. They've been greatly supportive of the conference and appreciate everything they've contributed. I think Jose Antonio is being a little modest in the sense that He's been a great force in bringing World Arbitration Update into being. And this was something we talked about and started 6 years ago, and it really was a creature of COVID. In 2021, we were all looking for connection and engagement with our communities. And the traditional conference like this was very much an in-person affair. And we decided that we needed to do something that was, as Jose Antonio was mentioning, a really international conference. So we organized the first conference virtually. We had contributors and sessions, not in person, but virtually, from every continent in the world. We had a day dedicated to Africa, a day dedicated to Southeast Asia. We had European panels. We had panels in North and South America. It really was a great, and I think this goes to the heart of why we founded WOW. WOW is Jose Antonio's preferred acronym. WOW. We founded it as fundamentally a way of just bringing people together in our community. I think Jose Antonio's introduction reflected that. Just listening to Martin talk about some of the history of the PCA, specifically with regard to today's topic, it calls to mind some of the similar parallel events, certainly in my life, and I think this goes for many of us. One of my first jobs was working for the Ontario Minister of Energy in the province of Ontario in Canada. And I was a legislative assistant carrying bags, going to committee meetings and writing memos. And one of my first tasks was to be the legislative assistant advising on our sustainable development body, which the Ontario government set up and the Minister of Energy was in charge of. And so I went to a lot of sustainable development meetings when I was in my 20s. And it really was inspiring and certainly something I carried on through law school. And on the connection of ISDS and public international law, Martin mentioned the activities here in the early 2000s of the PCA to become really a premier center for international investment arbitration. And I remember we held a conference here, I think it was in 2003, 2004, looking at some of the big public international law cases, and Brooks Daly was there, and we had Gaillard and Paulson and a whole group of folks talking about, all of our favorite cases, Horzow Factory and the Chin case, and all the usual PIL and PCIJ cases. And really, I think that's continued on, obviously, with the caseload and the incredible work that we've seen here at the PCA. And I just wanted to, as a final note, thank the PCA for hosting and for the generosity, and for Martin having continue that chain of interest in that intersection between ISDS and public international law. So with that note, I think we're going to move to our first panel. And if I can ask our experts to come up, I'll happily introduce our moderator, and then our moderator will introduce our experts. So let me introduce to you Professor Dr. Yannick Radi. He is a professor of public international law at the University of Louvain in Belgium, as we know, not too far. He is or has been an invited professor at the Hague Academy of International Law at NYU, Sciences Po. Yannick is an international arbitrator as well. He is on the ICSID panel of arbitrators, notably, and on the list of trade and sustainable development experts for EU FTAs, and on the list of arbitration for SAPANI for sport disputes. He has published extensively on the intersection between international investment law and international law regimes, as well as on international arbitration. He is notably the author of, and this is a great book, shout out, Rules and Practices of International Investment Law and Arbitration. This is a Cambridge publication, great text, and it's wonderful to have you here, Yannick, and looking forward to our most interesting and provocative expert panel.
Thank you very much, Yannick, for this introduction. Many thanks for the PCA for hosting us. Indeed. So good morning, good afternoon, or good evening for those who are online. So to introduce this conversation, I would like first to refer to the International Court of Justice itself and its advisory opinion. And in particular, here I have in mind the last paragraph of the opinion. I quote, "The questions posed by the General Assembly represent more than a legal problem. They concern an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. International law, whose authority has been invoked by the General Assembly, has an important but ultimately limited role in resolving this problem. A complete solution to this daunting and self-inflicted problem requires the contribution of all fields of human knowledge, whether law, science, economics, or any other. Above all, a lasting and satisfactory solution requires human will and wisdom at the individual, social, and political levels to change our habits, comforts, and current way of life in order to secure a future for ourselves and those who are yet to come." Through this opinion, the Court participates in the activities of the UN and the international community represented in that body, with the hope that its conclusion will allow the law to inform and guide social and political action to address the ongoing climate crisis. So this hope that the ICJ referred to has already materialized. Indeed, its conclusions have already sparked debates, actions at all levels. This is well illustrated by the resolution which was adopted by the UNGA this month, in which it expressed its determination, I quote, "to translate the Court's findings into enhanced multilateral cooperation and accelerated climate actions at all levels, consistent with international law." So those conclusions of the ICJ in its opinion, like those of ITLOS in its own opinion on climate change, has already also sparked action in our field as this topic of climate change is highly relevant in international investment law and arbitration. In this respect, it is worth noticing that the Court itself, in its opinion, refers to international investment law as one of those other rules of international law which may also be relevant under various circumstances in the context of climate change. And if you look at all the opinions, declarations made by the judges, it's interesting to note that Judge Cleveland, in his declaration, also referred to international investment law. So Sergio Diaz will discuss this in particular during the conversation. So to introduce the conference, this conversation is made of 3 parts. First, the first part aims at embedding climate law and the climate advisory opinions in their current geostrategic context and in climate discussions. The second part aims at stressing, shedding light on the key takeaways from those advisory opinions. Finally, the third part will give the opportunity to our speakers to share their views on the impact of the opinions on investment law and arbitration, which brings me last but not least to introduce our speakers, Sourgens and Sergio Diaz. So Sergio is an international lawyer with over a decade of experience in public international law with a focus on environmental and treaty law. He is currently the Legal Strategy Director at the Fossil Fuel Non-Proliferation Treaty initiative. He was formerly head of the treaty section at the Ministry of Foreign Affairs in Colombia. In addition to his practical activities, he is also working as a university professor at the Universidad de Rosario in Bogota. So thank you for having come to Europe. Frederick, thank you also for coming to Europe. So you are the James McCulloch Chair in Energy Law at Tulane University Law School and the Faculty Director of its Energy Law and Policy Center. You are an arbitrator on the AAA ICDR's energy list, a testifying expert on climate change and international energy law matters in investor-state arbitration, and a counsel in international energy dispute. You serve on the board of the American Society of International Law and the American branch of the International Law Association. You have published extensively with OUP in particular, your last book being A Theory of Global Energy Governance, published in 2025. There are many other books, but I will focus on this last one. So let's jump into the conversation now. Let's discuss our first topic. So, Sergio, could you please start embedding climate law and the opinions in the current geostrategic context and in climate discussions?
Thanks, Yannick. And thanks to also my panelists, Freddy. A pleasure to be here with you, and to Jose Antonio and Ian for inviting me here. It's always a pleasure to be at the Peace Palace for all of us that were born into the international system at moot courts. I think whenever we enter the Peace Palace, we always have the same feeling. I'm pretty sure that how Ezra is looking at me, he also has that feeling. So thanks a lot for that. But going directly to the point, because I know we don't have that much time. The advisory opinions, I think for many of us, the advisory opinions changed the landscape of international environmental law from one day to another, not because they actually mentioned something specifically new, because for many of us, what's inside the advisory opinion is actually something that we already thought that was clear in international law, but perhaps there was some debate in international law regarding the extent or how it should be interpreted. But all in all, I think what the advisory opinion says is basically what many of us in the international legal system, especially perhaps in the global south, were thinking that the norms actually were. But what's interesting is what has happened between the day that they were released and today. Because many thought that the advisory opinion was going to stay as that, as an opinion, and nothing was going to come out of it. But what really we have seen, at least in the environmental field, which is where I'm coming from today, we have seen that there has been a major shift in the way states are behaving regarding international environmental law and in other aspects of international law, and for these purposes, specifically on investment arbitration. And I'm going to refer to a very recent development that started exactly after the advisory opinion was rendered, and that ultimately showed its actual results in Santa Marta, Colombia, less than a month ago. And it's the first transition away, conference on the transitioning away from fossil fuels. This conference was a conference that has what the civil society in environmental, that works in environmental law, had thought that it should have happened a long time ago, but there was never momentum for it to happen. The advisory opinion was rendered, and less than a month after that, Colombia was announcing that the conference was going to take place. At first, nobody really made any fuss about it. It was announced in the London Climate Week a year ago, almost a year ago. And then came the General Assembly, the New York Climate Week. Nothing also came out of that. The momentum was really slow because many of the states were expecting to see what was going to happen at COP. Many of the states were expecting to see what was going to be the actual results of the advisory opinion for the climate talks in New York, in Brazil, in Belém. But there was a ongoing discussion, and I can say this due to my past in government, because my colleagues told me that many of the states were starting to think perhaps someone is going to be sued. Perhaps someone is going to be the first state to be sued after the advisory opinion came out. And everybody was expecting to see who was going to be the state, but perhaps nothing was going to happen because at COP talks were going to move forward and nothing was going to happen. Then came COP and nothing happened. All the states were talking about it, but nothing happened because fossil fuel talks were completely impossible to have there due to the consent rule. There were two major sides, one that wanted to talk about fossil fuels, another that didn't want to talk about fossil fuels. And then the last day of COP came and nothing had happened. And suddenly Colombia made the official announcement of the conference and the room was completely packed. There was not a single free space in that room when Colombia announced that the conference was going to take place. But most interestingly enough, the states that were in the stage with Colombia were the states that nobody was expecting to see there. The co-host was the Netherlands. There were a bunch of European states. There were a lot of Latin American states, but also African states, but also Pacific states, also Asian states. And suddenly there was a major momentum for starting to talk about fossil fuels and how transition away should occur and how multilateralism should be promoted, because suddenly states were realizing that something needed to be done because the law was already there. There wasn't any doubt that the transition was an obligation, but now there was actually a question on how we should do it. Then Santa Marta came on April, less than 3 weeks ago, 4 weeks ago, well, how time flies. And almost 60 states took to the stage to say, we all understand that there is an obligation to transition away from fossil fuels. That was something unheard of. It was the first conference and 60 states, not a single state, said something different. Yeah, all of them disagree on how they should do it, what are the actual extents of the obligations, but my point is that that advisory opinion actually had a major impact on geopolitics, so that's something really worth noting.
Okay, Sergio, so this momentum made possible by the opinion.
Exactly.
Thank you. So, Freddy, your views on this first point.
Thank you so much, and thank you for having me. It's always a pleasure to be here. I would like to take a slight detour. And that is to start off by placing us geostrategically in the moment that we are at the moment. And that moment is that we are seeing an increased amount of warfare around key energy nodes. You see it in Ukraine, and you see it around the Straits of Hormuz. And these flashpoints are flashpoints that are creating an enormous amount of stress on the global energy system. It is, in many ways, no accident that they're happening around key natural gas nodes, because natural gas is one of the key fuels that we need in order to satisfy global energy demands. So to the extent that you're looking at the advisory opinion and you're looking at the overall framework in which energy transition is happening, and you're looking at what it is doing what is the context in which it appears geostrategically, you see that a lot of what is happening at the moment in terms of energy transition is we're seeing a significant push towards what I think of as energy transition wars. So what do those do? I think what is critical to understand in this context is that before we closed the Strait of Hormuz, before the Strait of Hormuz was closed, you had still a significant demand for oil and gas. You still had a significant demand that was growing on the gas side for electricity demand, and you had an anticipated 19 million barrels per day needed by 2050 in terms of growth in oil demand. This would be a statistic on which OPEC and the IEA tend to agree more or less. when then you close the Strait of Hormuz, what you now see is a significant stress on global energy demand that can't actually be met anywhere else in the world at this particular point in time, which is leading to significant energy shortages, particularly in Asia. So to the extent that you're looking at what it is that we have to do, we will have to explore, develop, and produce more oil and gas in more places to create a safety valve on the global system in order to take pressure off some of those critical nodes that are now being used for geostrategic leverage. Which means that to the extent that you're looking at the advisory opinion, you have to look at the advisory opinion in light of what global reality is like, and then see, well, how is it that we can do this? And is the advisory opinion at all consistent with that reality that we face? I mean, it could be that the law would tell you one thing and reality would tell you another. And my hopeful view is that, in fact, the advisory opinion is completely consistent with doing what we need to do in order to decongest and in order to deconcentrate global value chains at the same time as decarbonizing them. So I think what, to me, is the key takeaway from the advisory opinion, both at the ICJ level and at the ITLOS level, is that what the key focus is decarbonization. It's not so much what is it that we're having as an energy input. It's not that we need to change the manner in which energy inputs happen. It is we need to decarbonize global energy, industrial, and agricultural systems. Many ways of doing that. The many ways of doing that are fundamentally respectful of the specific conditions in which states find themselves, leave significant policy room for states to make those determinations consistent with their own national conditions, is mindful of the bottom-up nature of climate action, and does not become overly prescriptive in terms of setting means for the global community to achieve these goals. So to the extent that states have a desire from a policy level to go in a direction of focusing more on energy inputs as their means to decarbonize, they can do that. To the extent that states look to decarbonization by means of carbon capture, they can do that. To the extent that states wish to lean more on nuclear energy, they can do that. But no state is necessarily forced into a particular means chosen by its peers. The one thing that I found interesting out of the advisory opinion, by the by, is to the extent that I were to identify the two countries most at risk of being sued, it is Canada and Germany. Canada, because the note that withdrawing from a treaty is not, in fact, sufficient to escape liability under that treaty. I will point out that the Kyoto Protocol was precisely Canada's move was, well, I'll get out of the Kyoto Protocol in order to avoid liability, and the court was reasonably clear in saying, I'm not so sure about that. And Germany, because the nuclear exit is something that has created all manner of problems in terms of, well, you could have avoided these emissions had you continued with your nuclear program. Have you, in fact, gotten to the same emission reductions that you would have achieved had the nuclear program stayed in effect? And I don't think they would have gotten there. So I think the two countries most likely to find themselves vulnerable as a matter of the advisory opinion are those two, and those are not the ones you would have expected. So there's a little bit of a disconnect, I find, in terms of what people expect out of the decision and what it might actually do.
Thank you, Freddy. So the advisory opinions is embedded into the realities, the geostrategic reality and the climate change reality, and there is obviously some tensions between those two realities. You seem to focus on one each of you, so which means that we're going to have a very lively conversation. So, Sergio, as to, from a legal point of view, the key takeaway from the advisory opinions, in your views?
Thanks, Yannick. And very interesting points that Freddy made, because I do agree that the last year has been quite interesting, because I like the phrase that you use, the law will tell you one thing and reality will tell you another. because I do think we have that problem exactly right now. But I do think that's also the reason why states are behaving why they are behaving, because they are fearing so much what's happening in Hormuz that they are looking for ways to try to escape the system, and that had, for instance, in Santa Marta, played a major role for states to be acting, to trying to change. But turning to the specific question that you are making, and I think it's also going to be part of what I want to discuss in the next question, is for me the main takeaway of the advisory opinion is how it reframed how international responsibility is going to be handled from here on out regarding environmental affairs, and how that can play a major role in investment arbitration, because the states are going to start to act differently now that the advisory opinion has been rendered. What do I mean? Before the advisory opinion came out, I think there was this kind of consent between states, or at least everybody accepted kind of that reading that the Paris Agreement was a toothless treaty. I don't know if that translates exactly the same in English as in Spanish, but basically that there were no means to make the Paris Agreement a binding agreement whatsoever. That almost all of the obligations in the Paris Agreement were soft obligations of the kind that states weren't going to be able to be sued for them, for the violation of them, because basically the system was a self-contained system where the responsibility for breaching the obligations was basically the name calling in the cup, and that was that. But when the advisory opinion came out and they say that not only the climate change treaties can be required before international tribunals, that there is no doubt whatsoever that you can sue another state for the violation of the Paris Agreement for having unfulfilling NDCs, that they are not meeting the requirements of being more ambitious and trying to attain the 1.5 goal, climate goal, but also that you can be responsible in international law for breaching the transboundary obligation, the obligation not to cause transboundary harm, and for breaching the obligation to cooperate. States that makes states think in a very different manner on how they are acting. Because, for instance, if you go to the last part of the advisory opinion where they answer question B, where they mention that, for instance, the licensing of new fossil fuel projects may be an internationally wrongful act. Yeah, they are not saying that it is an internationally wrongful act, but they are saying that it may be an internationally wrongful act. Now states need to think why it can be an internationally wrongful act. And it all depends on the due diligence obligation that you are, the way you are meeting the due diligence obligation. Yeah, it's going to depend on the state that it's authorizing the new fossil fuel project. It's going to depend on a lot of things. But the point is, if you don't do it correctly, then you are going to be able to be subjected to an international case. And that also means that beforehand, when states had the decision, for instance, to authorize or not a new project, they were mostly free to do it without any major concern. And if then the balance was between, if I do it, I'm going to face perhaps internal litigation, but I'm going to avoid an international investment case, then I'm going to do it because I don't want the investment case. But now, if you have in the balance perhaps an investment case versus an international law case, that's something that perhaps it's going to shift the balance. But I think that's more in the second part of the question.
Yeah, so we'll move to that in a few minutes. So giving tools to the Paris Agreement, in your view. So you referred to due diligence. Freddy, due diligence, this is what you wanted to talk about as well.
There's one thing that I just wanted to pick up on with what Sergio was saying, that I think, for the most part, I tend to think that the court did an admirable job in getting the Sphinx-like politics of this just right in order to nudge states. The one area where I would say it got it absolutely and catastrophically wrong is in its characterization of the Paris Agreement. And the reason for that is US foreign relations law. What the International Court of Justice has now done is it has made it impossible for the United States to rejoin that particular agreement. if the agreement contains substantive obligations, as the court now says, that agreement is subject to ratification and consent by the United States Senate. When the Paris Agreement was negotiated, the Obama administration was very clear to take all the words out when the French text had to be changed in order to make sure that that was precisely the result that was avoided. The court and the U.S. judge on the court was not mindful of the fact that there are reasons that we were walking a tightrope. So at this point, the United States cannot, under its own law, rejoin the Paris Agreement to the extent that the advisory opinion, in fact, gives an accurate reading of that agreement, which I think is catastrophic because I would think that the United States would have liked to, on the whole, in the long run, rejoin the Paris Agreement. And now it finds itself unable to do so. And so the easiest thing for any administration to say in avoiding this particular issue is, well, we can't. Because if we were to sign it, we need to send it to the Senate, and Senate ratification is impossible. It's impossible because the United States is also not a member of the United Nations Convention on the Law of the Sea, an agreement that most people, even in the United States, would have thought the United States should have joined. And so at this point, there is a real problem in this particular regard that I think they got the politics wrong on that one. And in terms of due diligence is, I think, the key tool to understanding how prevention in the climate context works. And I think the thing to understand about due diligence is that it's an obligation of conduct. It's not an obligation of result. It's not that you need to reach a particular emission reduction result or a particular target in terms of actual temperatures. It's that you have to go about a policymaking process in a manner that incorporates the climate concerns as a significant concern that you have to account for in your own policymaking, whether it be energy policy, whether it be agricultural policy, whether it be industrial policy. Not the only one, but it is a significant one. And to the extent that you're looking at the word stringent in both the ICJ and the ITLOS decisions, of what on earth does stringent due diligence mean, I think what both sets of courts and tribunals meant in that context is that to the extent that you get this wrong, to the extent that you undervalue the climate concern, you have these consequences that you know are going to be catastrophic. So what you have to do is you have to account for that. Now, accounting for that does not mean that you can't have an overshoot scenario. Because, I mean, spoiler alert, we're in an overshoot scenario. 1.5 is out of reach, 2 degrees is out of reach. Even if we stopped all human activity tomorrow, we are past 1.5, I'm reasonably certain of it. And I think we are coming up on 2 degrees anyways, right? So we're going to have to deal with overshoot scenarios. And I think, to my mind, what stringent due diligence means is that we need to actually address the adaptation that is necessary, actually address the overshoot. You can't have a policy that says, yes, we're going to overshoot, but I have no policy means of reducing the overshoot in the long run. You need to actually plan for that in your policy processes. To the extent you do that, you have a free choice of means, because each state is sovereign over its own energy policy. Each state has its own choice of means of political, economic, and social system. But as it makes these choices, it needs to have a plan. And so I think that, in many ways, is the good news, that due diligence doesn't put us in a straitjacket about how it is we have to do things, but that it does rather urgently tell us what the things is that we need to have a plan for in order to get from A to B. So to the extent we have that plan, and to the extent it is realistic, I think we can move forward with any means that we choose. And I think there are many different realistic pathways out there.
Thank you. So we have a few minutes left. Let's get closer to investment loan arbitration now to pave the way to the three panels. So, Sergio, in your view, the impact or the potential impact of the opinions on our field?
Thanks, Yannick. Well, I think the potential impact is very clearly described in Judge Cleveland's declaration. In fact, it's the last paragraph, I'm seeing it here, where she basically mentions that the advisory opinion, the major role that the advisory opinion is going to play in investment arbitration is that it has been clear in stating that when investment treaties are interpreted, they need to take into account the climate change obligations of states, be that the Paris Agreement, be that the Kyoto Protocol, or be that customary international law. And I think that that's very powerful, but something that it's really difficult to execute in practice. What do I mean? I think that perhaps the major difficulty that states are facing between fulfilling their obligations in the climate change regime and investment arbitration is what Jose Antonio was saying beforehand in his introduction. That's basically we have two systems that are not talking between one another. And I say this coming from a treaty office which had to deal with that specific difficulty in practice, which is we have two conflicting obligations many of the times that basically don't deal well with each other, although there are means to solve that. What do I mean? The Judge Cleveland also briefly summarized that, and it's the concept of regulatory chill that states fear, which is something that in practice I have dealt with in a personal capacity. For instance, this government, the current Colombian government, was going to issue a regulatory ban on the export of coal towards Israel due to the position of the government regarding the situation in Israel and Palestine. But the main discussion that we had when that decision was taken was how are we going to deal with the suits that are going to be presented towards Colombia after the decision is taken, because we know the suspects that are going to actually be presenting those arbitration notifications. So we had to actually very much think on what was going to happen. And that's not an environmental case, that's another completely different issue. But that's something that also happens in the environmental field. So whenever you're going to take a major, ambitious climate action, you have to think about that. And that's something that states have a very difficult time. And for instance, in Colombia also, we suffered about that when the Constitutional Court issued a major decision protecting the Páramos ecosystem, which resulted in 7 arbitrations presented mostly by Canadian companies, mining companies against Colombia. So that's an actual current thing, but there is an actual way to solve it, which is very simple, which is Article 31.3c of the Vienna Convention on the Law of Treaties. My concern there is that I don't know that the system is actually ready for that, because I do think that there is a major lack of knowledge about public international law, and many arbitrators are not equipped to be able to apply both arbitration rules and environmental rules at the same time. And I do think that that's a problem that we have in the current system that needs to be fixed. I think that the way to fix that is through amending investment treaties, be that in a unilateral capacity or via multilateral capacity, for instance, as the treaty that I currently represent, where you have actual rules that specifically make a carve-out for fossil fuels specifically, or environmental issues specifically, climate change issues specifically, but also requiring that arbitrators, when applying the obligations, actually take into account other rules, which is something that should happen. And for international public lawyers, I think we consider that it's a must and it's a given that it should occur, but that it's very difficult to find in investment arbitrations. If you go to Urbaser, yeah, perhaps in Urbaser you are going to find a rule. But in most of the other arbitrations, you are never going to find a mention to Article 31.3c, and if they do, they don't apply it correctly. So it should be something that it should be included in investment treaties, specifically explain how it should be done, and if not, be a basis for annulation of awards if that's necessary in order to oblige arbitrators to do it.
Thank you, Sergio. Freddy, what do you think?
Yeah, at the end of the day, I think one of the things you're going to see is a lot of pretextual invocations of climate change as a reason for non-climate related policy initiatives at this point. I think that arbitrators are going to be able to see through that reasonably straightforwardly. I think where the rubber meets the road is the policy that is at issue actually the result of a due diligence process that was engaged in consistently with the Paris Agreement, consistently with public international law? If the answer to that is yes, and then you have a conflict with existing investor rights, then you have the question of, well, how do you reconcile those two? The one thing that I will throw out is be careful what you wish for. To the extent that states are known to change their mind on energy projects that are long-term 30-year plus projects, you're going to find that your risk premium that you pay for the investments in energy projects that you want are going to climb, because you're not going to be a trusted partner. I will point out that much of the withdrawal from the Energy Charter Treaty was over a dispute with regard to feed-in tariffs in the renewable sector. It was not in the traditional thermal sector. So there is a real problem that would come out of it to the extent that you were to say, look, you know, we're just going to breach this agreement and or change this regulation and not pay out. You're going to have to pay for that one way or another. My sense is that you're going to be better off leaving the treaties in place, finding a way to settle the conflicts out, and hopefully find ways that are not necessarily arbitration, but conciliation or mediation to find solutions for these problems, and then show and signal to the marketplace that you're actually sticking by your word. I actually think that that is going to be the better policy path, and that doesn't require much of an amendment to investment treaties, because then you're honoring both at the same time, and you're letting the negotiation process take care of, well, exactly how much is it that you need to pay out in order to change trajectories. And so, you know, I'm actually reasonably optimistic that the system will work.
It's a nice way to conclude the conversation, to be optimistic. But in any case, I mean, the arbitrators will be key in the future to operationalize all recent development, and they will have to be aware of all those regimes and contexts that exist to settle disputes. So thank you to both of you. We have reached the time limit, so thank you for having paved the way for this 2 days conference. And now we leave the floor then to panel one. Thank you again. Join me in applauding our speakers.